The Fourth Circuit Court of Appeals came out with an opinion finding that people under the age of 21 are constitutionally allowed to possess handguns. Big decision that came out. Now, we don't know how long this is going to stay. This was a 2-1 ruling out of the Fourth Circuit Court of Appeals. And what that means is that this actually could go to the full panel in the Court of Appeals. And so this may be a short-lived verdict or not, right? This could stand. And of course, the government is very likely to appeal this. We're probably going to see this work its way up to the Supreme Court. Then we're going to have to ask ourselves, what is the Supreme Court going to do with this? And so the issue, of course, is surrounding the fact that people under the age of 21 are federally not allowed to have handguns. So we're going to go through this opinion, very interesting opinion, and we're going to learn a little bit more about the Fourth Circuit, and we're going to look back historically and see what Judge Richardson, the person who wrote the opinion, what he does here, because it's very interesting. He takes us back historically, back to the 1600s, 1700s, and looks at gun ownership in the hands of people who were underage back during that time before the Constitution was ratified. And if we look at the history of the country, then maybe we can say, well, that's what the founders were doing back then. That's what they meant when they wrote the Second Amendment. So maybe that's how we should apply it today. So let's take a look at what's going on. We're going to get a headline from Roll Call. It says the appeals court finds age-based handgun purchase ban unconstitutional. The judge says that they will not relegate the Second Amendment or 18 to 20-year-olds to a second-class status. Wow. Federal appeals court ruled on Tuesday that the federal ban is unconstitutional. Congress in the 1960s did not demonstrate a good enough reason for the law. Right? This is a federal law. It's been around for a long time. The judge said, sorry, it's terrible. 2-1 ruling, a 3-judge panel for the Fourth Circuit, which is in Richmond, Virginia, found that the Second Amendment right to keep and bear arms is no different from other constitutional rights that start at age 18. So the government must have a justification to restrict that right. Richardson, I clipped out a Donald Trump appointee, joined the majority opinion by another judge, Stephen A.G., a presidential George W. Bush appointee. So we got 2 Republican appointed judges who are finding this opinion. Now, let's take a look at the opinion before we learn a little bit more about the Fourth Circuit. I want to show you this. So it's Tanner Hirschfeld and Natalia Marshall. These are the 2 plaintiffs. They were suing or filing a complaint, seeking injunction against the ATF, Bureau of Alcohol, Firearms, Tobacco, Explosives, Marvin Richardson, acting director of ATF, as well as Merrick Garland, the current U.S. attorney. So they're all also naming... So Brady, the Giffords Law Center, Gabby Giffords, of course, was shot down here in Tucson, Arizona. And so they filed an amicus brief, which is a friend of the court, sort of a brief. So we've got these 2 individuals, Tanner Hirschfeld and Natalia Marshall. Let's see what's going on with them. They filed a suit, and here is where the Fourth Circuit is. So we kind of poke around the country. They're coming from this jurisdiction over here, which includes South Carolina, North Carolina, Virginia, West Virginia, and then, of course, Maryland, right? So we've got 5 states here in the Fourth Circuit. Here is Judge Richardson, who wrote the opinion. Born 1976, he's a judge for the Fourth Circuit. Nominated by Trump 2018, went to Vanderbilt, went to University of Chicago Law School, was a clerk for the Seventh Circuit, was a clerk for Rehnquist, really, the Supreme Court of the U.S., private practice for about 3 years in D.C., and a lot of other different positions. DEA Task Force, Organized Crime, Drug Enforcement Task Force, National Security and Anti-Terrorism Advisory Council, and so on. So that's the guy who wrote this. This is Richardson, right? And we're gonna go through this, some good stuff here. Let's read a little bit. It says, when do constitutional rights vest? When do you get them? How old are you? 18 or 22 or 21, 16 or 25? Why not 13 or 33? In the law, a line must sometimes be drawn, but there must be a reason why constitutional rights cannot be enjoyed until a certain age. Our nation's most cherished rights vest no later than 18, and the Second Amendment right is no different. Plaintiffs want an injunction. They want a declaratory judgment. They want to say that the federal laws that prevent gun dealers from selling handguns to 18, 19, or 20-year-olds, that violates the Second Amendment. They're saying that law unconstitutional. So we got to find a couple things. Number one, do 18-year-olds have rights in the first place? The court says yes. We first find that they do. They have Second Amendment rights. They enjoy almost every other constitutional rights that we have at the founding. Why not weapons? He says at the time of the founding, they served in the militia and they furnished their own weapons. Then we also have to look at the precedent, whether the government has met its burden to infringe upon that right. To justify the infringement, they've got to come up with some different justification for it. So we're going to go through that. We hold that the challenged federal laws and regulations are unconstitutional. under the Second Amendment. Despite the weighty interest in reducing crime and violence, well, we're not going to relegate the Second Amendment for 18 to 20-year-olds to a second-class status. Wow. So interesting take on this. Let's see where else this goes. Who are the plaintiffs? Who's suing in the first place? Why are they upset? Well, prospective handgun buyers, so the two people that we mentioned, they sued ATF. They want an injunction. They want a declaratory judgment. They're saying that what you're doing by not selling us these guns, it's violating the Second Amendment. 19-year-old is Natalia Marshall. She had a good reason to seek protection. Why? She had been forced to obtain a protective order against an abusive ex-boyfriend who, since the order, was arrested for unlawful possession of a firearm and controlled substances. He was released on bail, never came to the court, issued a warrant for his arrest, along with the threat from her boyfriend. She's a horse trainer, equestrian trainer, often in remote rural areas, interacts with unfamiliar people. She grew up training with guns, believes that a handgun's ease of carrying and training makes it the most effective tool for her protection. But because Marshall was 18 when she tried to buy a gun, couldn't do it. She preferred using a licensed dealer because they tend to have a wider supply, a good reputation, and a guarantee, but they would not sell it to her. She's now 19, remains unable to buy a handgun from a federally licensed dealer. The other plaintiff is Tanner Hirschfeld. He tried to buy one, but was denied. He was only 20. But he's since turned 21, no longer affected by these laws, so those are now moot. Marshall, however, is not yet 21, so this appeal may proceed. So what happened if she would have turned 21? Well, go buy a handgun. You no longer have a claim because it doesn't apply to you anymore, so there's nothing to complain about. So that would have been moot. But because she's not there yet, the other young man is, this can carry forward. So this was a very big opinion. I wanted to show you. I think I missed that. 141 pages. Okay, so look at the top of the first document. 141 pages up here. We are not going to go through all 141 of them, but I did clip out some interesting tidbits from my skimming of the opinion today. And a couple things I want to point out. I mentioned that he takes us back a little bit through the founding era, the history of the country. And I want to show you what's happening here. He talks about the founding era militia laws. He says the historical evidence from the founding shows that the 18 and 20-year-olds are protected by the Second Amendment. He said the militia laws during the founding provide powerful historical evidence. We can just look at the laws they had. Near the time of the ratification, the federal government in every state required 18-year-old men to be a part of the militia and to bring their own arms. Right? That was in the DC versus Heller case. This evidences the founding public's understanding that the militia and the Second Amendment encompassed 18-year-olds. Obvious. Right there. Just from the founding laws. These founding era militia laws illuminate broader rights that are enshrined in the Second Amendment. The civic purpose of preserving our nation's security sits at the Second Amendment's core. Being a part of the militia, having a firearm, and being prepared for action were vital to protecting the new republic. Right. So talking about this from a national security perspective, almost that this was critical, and we gave it to 18-year-olds. And so the response always to that is, of course, well, we don't really need that anymore. We've got police, we've got a military, and so you little American people, you Second Amendment lunatics like me, you don't need your guns because the police are going to handle that for you, there, buddy. As is the military, and so you don't need those anymore. Now, he goes through that argument and sort of dismantles that, right? And we're going to see some of that here. Militia laws show at the time of the founding that 18-year-olds have a Second Amendment right. Men trained to arms from their infancy and animated by the love of liberty will afford neither a cheap or easy conquest. So he quotes this, says, every militia law near the time required 18-year-olds to be a part of it. He also says that the militia clauses to better organize the militia for federal emergencies. Select militia should be set at age 18, according to one of another document that was published back during the time of the founding. So let me show you this. So this is the appendix here. And I want to show you that these are the pre-ratification militia laws. And so he goes through this, and you'll notice different citations. So in Connecticut, back in 1786, there was a law called Acts and Laws of the State of Connecticut in America. And they passed an act called an Act for Forming, Regulating, and Conducting the Military Force of this state. And guess what? The age was for Connecticut 16 years old in Connecticut, pre-ratification, prior to the founding of the country, prior to the ratification of the Constitution. They're looking back and saying, okay, well, they wrote the Constitution and the Second Amendment in order to fix the problems at the time. What were some of the problems at the time? Well, we needed an active militia and things like that. And in Connecticut, well, their age was 16. Delaware, 18. Georgia, 16. Maryland, 16. Massachusetts, New Hampshire, New Jersey, and New York, all 16. Right here we have here in New York an act to regulate the militia, 1786. We have another one in New Jersey, 1781. Another one from New Hampshire, another 1786. And so the list goes on and on. North Carolina, another 16. Rhode Island, another 16. South Carolina, Vermont, both 16. Virginia was 16 in 1775, and they bumped it up to 18 10 years later in 1785. Okay, and so pretty obvious that firearm possession was applicable to young people. And so the court is analogizing from there, right? So it's an interesting little journey back through some of the rules of the time. And we wrap up. It says the Justice Department will almost certainly appeal the decision, which comes during an incendiary national debate over gun control laws prompted by everyday shootings, as well as a series of mass shootings over the years at concert schools and public spaces, which we've been hearing a lot about, right? Remember this. We've been talking about Attorney General Merrick Garland coming out and talking all about gun violence, gun violence, gun violence, gun violence. Here this is now. Supreme Court, with the newly expanded 6-3 to conservative majority, has teed up a major case about state concealed carry laws, and the term starts in October. We're going to see how far the judges go. Meanwhile, Congress stands at a partisan deadlock over numerous gun control proposals backed mostly by Democrats, and he's issued executive orders taking other actions to combat what he calls an epidemic of gun violence. A lot of epidemics out there these days. Pandemics, the whole thing. All right, so that's what's happening. Let's take a look over at the watchingthewatchers.locals.com live chat and questions coming in. We've got Joe Snow, Ryan, that one Florida man. Sarah Smothers is here in the house. Let's see, Ryan's there as well. Okay, let's go over to the questions, see what we've got. Just a couple came in on this topic. We have, Sergeant Bob is here. Sergeant Bob's in the house. Sergeant Bob says, Sergeant Bob here with Miss Lucky. Hey, Sergeant. All my retired cop friends support the Second Amendment. Cops you see in uniform supporting gun control are most always politically appointed chiefs of police who can get fired if they refuse. Yeah, so that's interesting, right? Sort of you go along in order to preserve your job, right? And people do that all the time. That's just I'm just doing my job, man. I know, sorry. I got a wife and kids at home. She's screaming at me. She just texted me, pick up the milk on the way home. Whatever, you're getting arrested. I don't have time to talk about it. And, they deal with a lot of the same stresses that the rest of us do. But the Second Amendment stuff, it's good to know that there are many officers out there like you, Sergeant Bob, who support that, because I think, it serves the police as much as everybody else. Like, we all want that, right? We all want self-protection. We all want to be able to defend ourselves and our families. And I appreciate your comment on that. And I know I owe you an email, Sergeant Bob. You're on my list. You're on my list. And you're there. You're at the top of it. Sergeant Bob has a book that we're going to be telling you about shortly. When we get there. Thank you so much for being here, Sergeant Bob. We've got LIVECHAT again, says, Rob, thanks for a shout out. Glad to join the community. Always happy for a win on the Second Amendment issue. Also, the handle is pronounced Lavoisier, as in the famous chemist, Lavoisier. Lavoisier. So I'm going to try to get that. I love that. Lavoisier. I've told a story here, I think, on the show. When I was in law school, we had a substitute professor come in. And she was going through attendance, and she was reading the attendance. She got to my name, and she said, Mr. Gruler? And I wasn't paying attention. I had no idea who the hell she was talking about. And nobody else in the class did either. And everybody's sort of looking at each other going, who's Gruler? Everybody's looking around. And then somebody's like, I think that might be you. And I was like, Gruler? And she goes, oh, Gruler. And so it was kind of a running little gag that my name was French now. It's Robert Gruler, which is very, very fancy, like Lavoisier. So I like that. I think that's pretty fun. If I ever move to France and subject myself to their mandatory vaccines, then maybe I'll switch that up. Good to see you, Lavoisier. I'm so grateful that you're here, and I love the name. I'm going to have fun with that one. We've got Ghost Gunner here, says, the more wins we get in circuit courts, that get appealed, the better. There's several in the ninth as well. Let them appeal to SCOTUS. They are very pro Second Amendment. I want an NFA and GCA to get in front of them, strike them all down. Yeah, right. If a 6-3 conservative court's going to be good for anything, hopefully it's something meaningful. Good to see you, Ghost Gunner. We'll see if it gets there. Thunder 7 is here, says Rob. The Dems have been trying to take the guns away from the people. Isn't the Second Amendment a civil right that cannot be infringed upon? It is a civil right. It is a fundamental right. It is a constitutional amendment. That means it is about as guaranteed as you can get in this country. That doesn't mean that it is beyond any regulation or beyond any sort of infringement, right? The courts have said all sorts of infringements are appropriate. For example, right, if you're a convicted felon, you don't get that anymore. Sorry. You forfeited that right by, doing what they consider to be a breach of society's rules. And so there are different things that the courts have held to be valid infringements, but I think that they have gone way too far in many states. Looking at you, California. We have 3 Girlies is here, says few points. Our founding fathers did not like the idea of a standing army. They wanted us to have a militia, mainly because of the tyrannical verbiage that was spewing out of Joe Biden's mouth lately. Biden even said that the American people would struggle with fighting against F-15s and nuclear weapons. I think Swalwell said that too. Final point, if an 18-year-old can fight in our army, why can't they buy their own firearm? It's a great question, and it's because of political hypocrisy and nonsense is really what it comes down to. Totally agree with you. Candidly, I think that should be extended to alcohol too, right? And I don't even drink alcohol anymore. But yes, right, if you're going to be somebody who's going to go put your life on the line, you can't have a beer after that. I mean, what are you talking about, right? So I think that a lot of what we have going on in this country is sort of, remnants of older eras, and we're due up for some rethinking about a lot of things, but not the Second Amendment. That's pretty robust. That shouldn't be going anywhere. Chris is here. Chris says, at 18, I had completed the Marine Corps boot camp, School of Infantry, security force training, a typical day of duty for me. Had me armed with an M16A2 9mm Beretta and a 12-gauge shotgun. It has never made sense that you can volunteer to serve at 17 in the U.S., but could not personally purchase one of the weapon systems I was highly trained and proficient in using for 3 years after I enlisted. I think this is a change that was a long time coming, and thank you, Chris, for sharing that with us, for your service, and for all of your experience there, right? That's such a great way to summarize it. M16A2, 9mm Beretta, 12-gauge shotgun. And you are a trained user of those firearms. But if you wanted to go back at your home state and go buy a firearm from a federally licensed dealer, sorry, you're not qualified. Wild times. Great question. Thank you for that, Chris. And thank you to all of you who are supporting us over there at watchingthewatchers.locals.com. Much, much appreciated. Thanks so much for watching. Before you head out, I want to just remind you that I am a criminal defense lawyer here in Scottsdale, Arizona, where my team and I, we've got a long history of helping good people facing criminal charges to find safety, clarity, and hope in their cases and beyond that in their lives. Our phone number for a free case evaluation is 480-787-0394. You can also find us online at www.rrlawaz.com. We can help with any type of criminal charge in the state of Arizona. Things like DUI, drug offenses, misdemeanor offenses. And we can also help with clearing up old case records, like expunging cases or making sure that you can restore your rights so that you can vote again or possess a firearm again or apply for some other federal benefits. We can remove mugshots off the internet. Basically, anytime that you or somebody you know or love is in trouble with the law in the state of Arizona, we have an amazing team of people. We would just love the opportunity to help. And our phone number, of course, 480-787-0394. And if you don't need any legal services, that's a very good thing, but you may be interested in some informational offerings so that you are prepared if you do have to deal with the police. And of course, I want to invite you to head on over to gumroad.com/Robert Gruler. You'll notice here, I've got several different trainings that are available, including the law enforcement interaction training. This is the 1, 2, 3 rule for dealing with the police. It's one rule you need, 2 questions that the police can ask of you, and 3 responses if they ask you a problematic question. So that's available now. You can also get a load up by personal productivity system here called Existence Systems. Fun little course. And then we have here, if you're a lawyer or a legal professional, be sure to check out this program. We are meeting twice every month. Again, all of this over at gumroad.com/Robert Gruler. And if none of that sounds any good to you, well, just go ahead and give us a follow, because I'm working on some other products and some other offerings. And of course, if you have not already done so, want to invite you one more time to head on over to watchingthewatchers.locals.com. It's where you can support the show, and it's where we can connect. We've got monthly Zoom meetings and a lot of other goodies coming up. So I look forward to seeing you there. Thank you so much for watching and for all of your love and support. I will see you on the next one.